Hi, everyone. Thank you very much for joining us today. Just wanted to thank you all for being here. I know that we have many important demands and obligations tying us in all directions these days, so we really do appreciate your time coming in. On that point, in preparation for today's webinar, I even tried to give myself a haircut. And so here we have Exhibit A, why salons and hairdressers should be essential services for all Canadians. So I just wanted to again welcome you on behalf of my fellow speakers. We are very, very excited and thrilled today to welcome Catherine Bate that will be talking with us today. And Catherine Bate is the Chief Legal and Policy Officer for AdStandards Canada. And I'm also joined with my partner, Louis Reddick, who is a key member of our advertising and product regulatory group. And I am an ABCnet and also a partner in the advertising and product regulatory group. And so today we'll be going over some of the important and hot topic advertising and regulatory issues that have come up in response to COVID-19. Next slide, please. So just to give you an overview of certainly the topics that we'll be discussing today. As you can see here, we'll be talking about a variety of products, how they're regulated, and some of the advertising issues that have arisen in response to COVID-19. And then we will hand it over to Catherine to discuss the types of issues that AdStandards is seeing in response to COVID-19 and, importantly, some of the consumer complaints they're receiving that are specifically in reference to COVID-19 advertising. Next slide, please. So to give you a sense of the current environment, there has been an unprecedented demand and urgent need for certain categories of products. And most importantly, we have hand sanitizers, hard surface disinfectants, and certain medical devices. And to give you an idea of that unprecedented demand, Statistics Canada reported that the demand for hand sanitizers has increased by 735% for the period ending March 14th, 2020 versus that same period last year. And we see that same trend for all of the product categories that I just referenced. And so we really do see, and are in fact not surprised to see, this unprecedented demand and urgent need for these products. So in response, the government and its agencies have started to implement emergency measures to help stabilize that supply and increase that supply just to ensure that those needs are met in order to respond to this incredible health risk that we're all facing. Now, the types of risks that the businesses that want to take advantage of that demand have to consider are the regulatory, advertising, and product liability risks. And so on the regulatory side, these are heavily regulated products. And there are a variety of different prescribed requirements that must be made to import, manufacture, or sell these products. And also their advertising is strictly regulated. So that's to say the types of claims that can be made about them and the benefits that they provide. And finally, we see a product liability issue emerging increasingly often now as these businesses enter into the space and get exemptions from certain of the legislative requirements. We still have to consider the common law product liability issues and risks that arise. So notwithstanding that you may have approval from a regulatory authority to sell that product and be exempt from certain requirements, so for example, safety labeling, you still need to consider whether or not that exemption will help mitigate some of the product liability risk if someone is in fact injured using your product and issues a claim against you on the basis of the common law product liability. So these are important risks and considerations that any business needs to consider and address before entering into this space. So to give you a sense of, next slide, please, how these risks are materializing. When we first saw COVID-19 come out and the huge influx of products enter the market, it was a bit of the Wild West. And we saw all these different businesses trying to take advantage of this incredible demand for these products. And we now see the regulatory agencies starting to crack down on illegal or non-compliant activities. On this point, on May 6th, the Competition Bureau issued a press release indicating they're cracking down on deceptive marketing claims about COVID-19 prevention or treatment. So they are actively monitoring the marketplace now and telling businesses that this is the time to comply. Otherwise, they're going to start issuing some very serious financial penalties and even potentially jail time. And we have seen an uptick in recent regulatory and enforcement actions. And so they're coordinating this effort with Health Canada. And it's important to note that Health Canada, as indicated in this press release, has not yet approved any product to prevent, treat, or cure COVID-19. And that's a very important point to make and to consider. So these direct claims are really not ones that we should be making about these types of products. Next slide, please. And to give you a sense of the regulatory landscape that we're dealing with, I am going to hand things over to Lewis.
So I'm going to speak a bit about the regulatory aspect of some of these products that are becoming important in response to COVID-19, as many of our clients and companies in Canada are trying to introduce these products into Canada. So the first product I'm going to speak to with respect to the regulatory aspect is hand sanitizers. As you can imagine, hand sanitizers is a key tool in the fight against COVID. Many of our clients are looking to contribute and get involved with respect to the introduction of hand sanitizers into the Canadian marketplace. Now, as these are unprecedented times, Health Canada is taking unprecedented measures to help companies achieve those goals. So with respect to a natural health product, let me start off by saying most hand sanitizers are in the natural health product category. There are some that are also in the non-prescription drug category. And for both, they both need a market authorization normally to get into Canada, to be sold legally in Canada. So for a natural health product, that would be an NPN number, and for an over-the-counter drug, that would be a DIN number. In the current environment, Health Canada is taking alternative approaches to allowing some of these products to get into the market, including some form of recognition of foreign approvals. For example, a lot of our clients are now bringing products approved for sale in the United States by the FDA into Canada, not necessarily with an NPN. However, Health Canada's relaxed approach, or more relaxed approach, to the introduction of these products into Canada isn't a free-for-all, and it doesn't mean that companies could do just whatever they want. So the importation of these products still require the required license. For a natural health product, that would be a site license, and for an OTC, that would be a drug establishment license. The good news is that Health Canada has been very creative in its approach to the import licenses. For example, if we need an import license to bring a product in, we have gotten some in as little as 24 hours. Sometimes the import license will be qualified specific to a time period dealing with COVID or specific to that product. Other times, and it's very circumstantial in terms of the facts at hand, they're broader. But at the end of the day, we're seeing Health Canada take days to approve the importation of these products, when for a natural health product, typically it's been 60 to 90 days. And while we see far less on the non-prescription drug side taking advantage of these programs, I mean, getting a drug establishment license could take upwards of a year. So we're definitely seeing a much more aggressive approach to helping companies participate in getting hand sanitizers to market. Next slide. So I kind of spoke about this already. I apologize. One thing I do want to add to what I've already mentioned or two things. One is it's important that when we're looking at foreign approvals, Health Canada has not been specific in which foreign countries it would recognize. It uses language that references similar foreign jurisdictions, but of course, what does that mean? In our experience, we're seeing the vast majority of the products, to be honest with you, coming from the United States. And so if it has the FDA registration number, that's really been what's been very helpful in getting these products to market quickly. Another thing that's very important to note is that when Health Canada initiated this leniency for hand sanitizers, it was pretty relaxed with respect to labeling. They've dialed that back a bit. So with respect to labeling, for example, where initially they were alluding to the idea that you could have a US labeled product, now they're indicating that both official languages need to be available to the customer. Now, it doesn't necessarily need to be on the label itself, but there needs to be a clear indication of a website where a consumer could go to see the other language. Typically, obviously, if it's a US label, it's going to be in English only, and online you would see the French version of the label. But the wording of the policy really speaks to the official languages. Next slide. Sorry, okay. So there is also an accelerated program to get product licenses. So you don't simply need to rely on foreign companies getting their approvals through, getting the product to market via the US approval. There's a fast track to get an actual natural product number, a natural health product license from Health Canada. Again, we've seen licenses issued in as few as a couple of days. And we've had clients introduce product to market fully set up within a week. Now, I would say Health Canada is not quite as fast today as they were at the beginning of the process, but they're still quite efficient at addressing these concerns, unfortunately at the expense of the regular day-to-day business product launches. Next slide. So now Renee is going to speak to us about claims with respect to hand sanitizers.
Yeah, absolutely. Thank you, Louis. And so for those products that have obtained a market authorization by complying with the monograph, so that's to say the antiseptic cleansers monograph, you see here the types of claims that are permitted to be made about those products. And again, you will note that they are general claims about antibacterial, antiseptic effect. They don't speak exactly to treating or preventing COVID-19. And so it's important to consider that when you are preparing your advertising materials about these types of products. You see here that it just speaks to broad antibacterial action or the ways that these products kill harmful bacteria and germs. So if you are looking to obtain a different type of claim, then you have to go to Health Canada and obtain their approval for that specific claim. And you have to submit evidence to them of efficacy of the product and support that your product does in fact provide that benefit. So you are really limited here in the type of claims that you can make to help sell that hand sanitizer. Next slide, please. So I'm now going to hand it back over to Louis to discuss a new category, sorry, not a new category, a different category of products, so hard surface disinfectants.
Okay, so with respect to hard surface disinfectants, again, Health Canada is prioritizing everything related to COVID. So there is an opportunity to get a DIN for a hard surface disinfectant on an expedited basis. I think one of the issues with, not issues, but one of the benefits with hard surface disinfectants, unlike other drug products, is you actually don't need a drug establishment license to import it. So the importation barrier is eliminated, and therefore there are opportunities for companies to get hard surface disinfectants into the Canadian market at a much quicker pace in the current environment. Next slide. So like the hand sanitizers, they are recognizing approvals from foreign jurisdictions to help meet the need of the Canadian supply or the Canadian demand. As well, though there is an expectation for bilingual labeling to be available to the consumer in very much the same manner as what is expected for hand sanitizers. Next slide. So Renee is going to speak to us about some of the claims associated with hard surface disinfectants.
Yes, absolutely. And sorry, just before I do that, at the beginning of the presentation, I neglected to mention that if you have any questions, please feel free to submit them through the Q&A functionality at the end of the presentation. We'll take some time to answer questions. So please feel free to submit them. So as Louis said, we here have some of the approved claims that can be made with respect to hard surface disinfectants. And importantly here, it's important to note that Health Canada has permitted indirect efficacy claims for certain categories of hard surface disinfectants. So if you meet one of the three conditions noted there, so that's to say, it's labeled as a broad spectrum viricide, carries specific claims against prescribed non-envelope viruses, or carries specific claims against a prescribed coronavirus, you can make an indirect efficacy claim. And an example of that is that provided in quotes below. So this product, noting the product, is a broad spectrum virucidal hard surface disinfectant and is expected to inactivate SARS-CoV-2, so the virus that causes COVID-19. So you see there, it's the indirect aspect of that claim. It's expected to inactivate. So there it's not directly stating that it will. And so this is really as close as we can get at this time to those types of claims that we want to make about the efficacy of a product in terms of treating or preventing COVID-19. And that is important to note that these claims are permitted in respect of those classes of hard surface disinfectants. And I'm just going to hand things over to Louis to discuss the list that Health Canada maintains about these types of products.
All right, so Health Canada, very interestingly, is maintaining a list of disinfectants with evidence for use against COVID-19 when the product meets the criteria that was just explained by Renee. So it's very interesting because on one side, Health Canada says, you know, for these products, you cannot make any direct COVID-19 claims, only indirect COVID-19 claims. And then with the other hand, they're maintaining a list of products that are recommended for use against COVID-19. Setting that aside, one of the things about this list is that it's not automated. So even though Health Canada has kind of their DIN approvals for hard surface disinfectants and intuitively should know which products meet the requirements to be on this list and, you know, for lack of a better word, automate the population of this list from its own database. It's actually not doing that. It's relying on companies with those approvals to reach back to Health Canada and say, you know, hey, Health Canada, we have a product that is already approved by you for these claims. Can we please have that product added to the list? The email address for this is on the slide deck. Should you be one of those companies who have such a product and not realize that you actually have to ask to be on this list, but it's definitely a request-based list. Next slide. So now I'm going to talk a bit about cosmetics as the last kind of product category we're talking about with respect to COVID-19. So from a Canadian perspective, all cosmetics must be notified to Health Canada in advance of importation into Canada. And in short, must be compliant, right? Must have a Canadian label, for example. Once again, Health Canada is very concerned that there's going to be a shortage of products used by Canadians to cleanse themselves, which would be helpful in mitigating the risks of the spread associated with COVID-19. So Health Canada is, again, being lenient for these very specific types of cosmetics, i.e. cleansing cosmetics, and allowing the importation and sale of US labeled or one language labeled cosmetics. In doing so, again, we go back to the issues we raised with the hand sanitizer and the hard surface disinfectant, which is that it still needs to be made clear to the consumer in some form of mechanism where they could find the other official language, i.e. the French version online. But again, this illustrates, frankly, in my entire career, I've never seen anything like this, where Health Canada is allowing through policy a fundamental deviation of the law in order to achieve some greater good for the health and safety of Canadians. And even to the point of allowing non-compliant cosmetics. Next slide, sorry. So now I'm going to pass it off to Renee, who's going to talk to us about the claims associated with cosmetics.
Yeah, absolutely. So cosmetics are only allowed to make certain non-therapeutic claims. So you really can't talk about any type of disease prevention or treatment effect. And that is a source of frustration in these times for many businesses, where we have many public health authorities indicating the incredible importance of washing your hands with soap or with washes to help prevent the spread of COVID-19. It's a message that is repeated to us often, and by health officials at every level of government. And so we have this sort of strange situation we're in, where we want to advance our products as being suitable candidates for those practices, but we really can't talk about any type of disease prevention effect. And so you see that kills germs and any other type of antibacterial claims are prohibited. And so where can we sort of explore the space and try and take advantage of the opportunities available to us is we can talk about cleansing and the effect the product has in cleaning hands, but we really need to be careful to stay clear of any type of disease prevention. And on that point, we see a lot of advertising wanting to echo the 20-second rule and the importance of washing hands to help prevent the spread of COVID-19. And we really can't do that directly. And so we can speak about the importance of washing our hands, and we can also speak of some of the other cosmetic benefits that are associated with that. So moisturization, softening skin, things like that. But really looking at the overall general impression of the ad to determine, are we staying on the safe side, so that's to say about cleansing, or are we really conveying a message here about the use of the product to prevent the spread of COVID-19? And there is some gray area between those two extremes, and you have to be very careful in navigating those waters. But that is the current environment we're dealing with, and some of the limitations we have when trying to advertise soaps and washes in these times. Next slide, please. Well, now I'm going to hand things back over to Louis to discuss medical devices.
So I believe when I spoke about cosmetics, I mentioned it was the last category I was going to speak about, and I completely forgot that I am also speaking about medical devices. So this is the last category I'm going to speak about. So medical devices, Health Canada is taking a similar approach, but it's a little bit different. So in the medical device world, Health Canada issued an interim order respecting the importation and sale of medical devices for use in relation to COVID-19. Effectively, medical devices normally require medical device licenses if it's a class 2, 3, or 4 medical device. I think that's an important aspect because most medical devices we're used to hearing about with respect to COVID, albeit they're not the only medical devices being used with respect to COVID, are personal protection products such as masks and gowns. Those are class 1 medical devices. So as a product, those don't typically need a medical device. But there are others we're certainly working on as we speak that would normally need a medical device. And then the other aspect of importing and selling medical devices is the requirement for a medical device establishment license. And so a medical device establishment license has exemptions in terms of certain importers don't normally require an MDEL, but by product, there's no exemption. So whether it's a class 1, 2, 3, or 4 medical device, it would normally require an MDEL. And so Health Canada has provided this alternative approval route that's supposed to be faster and more focused to allow importers and sellers to import and sell COVID-related medical devices that don't necessarily have the necessary medical device license or medical device establishment license to do so. And this is supposed to be faster. And when I say about supposed to be faster, it's very, very new. So we don't actually have the practice to know how fast it's going to be on a regular basis. It didn't start as early as, let's say, the hand sanitizers, which was out much earlier. So it's a little bit of a wait and see how this is going to work out, but I expect that it's actually going to be very positive. It's going to allow companies to get their products to market very, very quickly. I should also point out that a number of current importers don't need either the interim order or a medical device establishment license. For example, a retailer or a healthcare facility importing something like a mask, well, the mask doesn't need a medical device license, and a retailer or healthcare facility doesn't need an MDEL. So there are situations where this isn't even necessary, albeit the products still need to be compliant. Next slide. So, so with respect to claims associated with medical devices, it's a little bit different than the way we think about claims for drugs or natural health products or even cosmetics. So in the, well, maybe a little closer to cosmetics. So in the medical device world, the formal position of Health Canada is that they're not really approving an indication for use. They're approving a functional purpose, but not a recommended use. So their position would be that a claim doesn't necessarily need to be, and I say this in quotes, approved. That being said, like with all products, all claims must be true and not misleading. And you know, I would be very cautious about making direct COVID-19 claims in the same way as we discussed with respect to hand sanitizers, not hand sanitizers, sorry, hard surface disinfectants, because frankly, it's just a high-risk claim. I mean, if you're going to make a claim, you need very, very strong evidence to support it, and you know, it would be a very difficult claim to support. Next slide.
Okay, great. So now, as you just saw, we've gone over some of the various measures that have been implemented to try and expedite and facilitate the supply of these products to help meet the demand that is extraordinary and you know, really once in a lifetime. So we gave a broad overview of those different pathways, and they are quite technical. So we have provided a list of reference materials here, and after the presentation is done, we are happy to share the slide deck with you so that you have those reference materials there for your use. And you'll see it's a long list. So there's a lot of measures that have been taken to try and address the COVID-19 crisis. And so we just wanted to have those for you so that you can take the time and really have a look at them in your own time. And if you have any questions, please feel free to reach out to us. I am now going to pass things over to Catherine to go over some of the various ways that the COVID-19 crisis has affected the services provided by AdStandards and the types of complaints they're receiving from consumers.
Thank you so much, Renee, and thank you to Gowlings for inviting me today. Just want to take a moment to talk a little bit about AdStandards to kind of level set for anyone who's not familiar with who we are and what we do. AdStandards is Canada's national independent self-regulatory body for the advertising industry. And what that means is that we are an organization originally created by industry to assist both consumers and industry in setting the bar for advertising in Canada. We do this through a number of different ways. As the bubbles appear, you'll see the first one is clearance. I'm going to talk a little bit about pre-clearance and what we do to assist industry with respect to particularly the products that you've just heard about. Secondly, the Canadian Code of Advertising Standards, and this is where the bulk of my conversation will happen today. Through the code, we administer consumer complaints, as well as disputes between advertisers, and a few of the other things that we're involved with, including oversight and compliance check for DAC's Ad Choices programs, industry initiatives such as the Children's Advertising, Spirits Code, automotive advertising. Specific to COVID, well, not specific to COVID, but keeping us very busy these days. We're very proud to work with the federal government and with the government of British Columbia to support their mandates of nonpartisan advertising. So we review advertising that comes through those two jurisdictions to help to ensure that the advertising is nonpartisan. So we're very busy, as one can imagine, with the government advertising going on related to COVID in both of those jurisdictions right now, as well as education and outreach. So again, thanks to Gowlings for having me today. To the next slide, please. So as I mentioned, Ad Standards offers a pre-clearance function. And again, for anyone who might wonder what that is, advertising pre-clearance generally is not necessarily required by law, but we do offer advertising copy review and advisory services in 5 regulated categories. And for the purposes of today, most importantly, in cosmetics, natural health products, and health products generally. So DINs, over-the-counter, we look at things for the hard disinfectants, for hard surface disinfectants, right through to soaps, to DINs, so you name it and we can be of assistance. We, as a practical matter, advertising going on to broadcast typically requires pre-clearance. The broadcasters will look for Ad Standards pre-clearance number. In many other media, for other sectors, it may be optional in terms of whether or not you seek Ad Standards pre-clearance, but we can help to negotiate some of those gray areas that you've heard about so far. We'll go on to the next slide. What we're there for is to help uphold existing laws, regulations, and Health Canada guidelines. So of course, we're looking first and foremost in these categories generally with respect to the Food and Drugs Act, as well as all of Health Canada's associated guidelines. So this is the before the advertising comes out phase of Ad Standards. We're here to provide that resource and to review the creative to help ensure compliance before things go out. This, of course, helps to weed out, if you will, that advertising that may be not permissible. So ads for non-authorized products or off-label or unauthorized claims that aren't included in product licenses or TMLs. When those, so that's probably not most of this audience. Most of this audience is probably looking just to navigate those gray areas. And that's where we can be of help to identify where there could be bleed, what we understand of Health Canada's interpretation. So much as what you've heard, is the ad talking about cleansing germs or killing germs? Is the ad talking about disinfecting? Is it a bacteria claim? Is it a virus claim? And is it creating a halo that is implying a claim about COVID-19 or stating a claim about COVID-19 that isn't yet authorized or otherwise allowed by Health Canada? So that's our pre-clearance function. But with the next slide, let me move on to talk about the Canadian Code of Advertising Standards. And here we have the clauses of the code. So again, for anyone not familiar, this is a self-regulatory code administered by Ad Standards. The 14 clauses here are intended to set the groundwork for self-regulation in the advertising industry in Canada. The ones highlighted in blue are those about which we receive the most complaints typically. These are the areas that are most of concern to consumers. And we move to the next slide, you'll see a slightly different highlighted list. This is where we're seeing the complaints about related specifically to COVID-19. So again, this can be a whole range of issues, and I'll divide it kind of into 2 parts when we look at this list. I'm going to dive into it a little further in just a moment, but we have the accuracy and clarity. Again, is the claim truthful, not misleading in general impression, and is it substantiated? And that ties in as well professional or scientific claims. Is this represented as being a scientific claim, an official performance claim, or is it implying that it has that scientific rigor when in fact it does not? The other clauses highlighted here, 10, 11, and 14, those are more sometimes subjective. It's how does the commercial appear? what is implied or intended, and we'll go through some examples in just a moment. And actually, let's go to the next slide to talk through some of these specifics. So in general, let me level set with some numbers. So far since the beginning of March, middle of March up until last week, we received a total of 30 complaints about advertising, specifically in some way calling out concerns about COVID-19. 21 of those complaints were reviewed by AdStandards staff. I'm not going to be able to talk about the specifics today. Some of them have been heard by our Standards Council. I'll talk about the process in just a minute. Some have been through and are subject to appeal. Others are pending and in process. So I'm not going to talk about the exact commercials today, but I will give some themes that we're seeing emerge. So as I mentioned, there's 21 ads that have been reviewed by staff. These range from misleading or unsubstantiated claims about the products, so again, helping to prevent the spread of virus, offering cures for those affected by COVID-19. Those kind of clause 1, is it truthful, accurate, substantiated, both in literal meaning as well as general impression. Then we have the category of ads that are more looking at the clause 10 and 14. So it should say we had, of the 21 complaints we reviewed, 11 did not raise issues under the code. We had 2 that are specific to 10 and 14, and these were concerns related to, again, depictions of activities. Here we have unsafe hygiene or etiquette when coughing or sneezing. Again, what might have seemed very banal, not paid a lot of attention to if it was shot, say 6 months ago, suddenly now has new imported importance in terms of those sorts of depictions. The same with ads that seem to promote social gatherings or events. Questions as to whether or not those reflect past time, a future aspiration, or seem to be crossing a line to encourage unsafe, dangerous, or even illegal behavior in these days of COVID. So whether or not, as I say, these cases are still up for adjudication, whether or not they fall into an actual code violation, I think it's important for advertisers to be aware that even if they don't cross a line, consumers are very sensitive to these issues right now. And these are likely to be moving targets as consumer sensitivity, as well as out and out public health orders vary over time and by jurisdiction as we go. We have also received complaints concerning scarcity of advertised products, particularly for personal protective equipment, and that's writ large. That can be anything from masks, gloves, to even disinfectant products. We also receive complaints about price gouging. Now, we don't address price gouging per se. Our code does address misleading price claims. So for those familiar with the Competition Act, this is like the ordinary selling price types of claims. So a savings is implied, but it's not actually a substantiated savings. But the advertisement of a price, if it's accurate, so what the advertiser chooses to set as their selling price, that's not something that we regulate. However, there are several provinces, Ontario included, that have price gouging legislation, and so complaints in that area, we coordinate to send those over to the applicable provincial consumer protection authority. Certain other complaints we will send to Health Canada. We've had 9 of our complaints that we've sent to Health Canada, and that's in accordance with our role in a partnership with Health Canada to report unauthorized health claims. So those we don't look at strictly under the code. Again, when it's dealing with those health claim issues, we will forward those to Health Canada for their enforcement. Moving on to the next slide. Early during the outbreak and pandemic of COVID-19, Ad Standards released an advisory, and I'll draw that to your attention again. You'll get the slide deck later so you can follow the link to read the full text of advisory. This was particularly focused on looking at claim substantiation obligations, both with respect to health products and scientific claims more broadly. And we'll go to the next slide just to break that down a little bit. So again, the advisory deals with both the clearance and the obligation for products generally to be authorized by Health Canada and the claims related to them to be authorized in this kind of changing landscape that we see that Lewis and Renee have spoken about in terms of product approvals right now. And then also with respect to standards. So a few tips to keep in mind. Again, with respect to claims, to be very careful what we're seeing with complaints and also when things come in for pre-clearance, but claims not being overbroad to ensure that they aren't distorted or overstated. Even advertisers with the best of intentions and very solid claims might be implying more. I've heard the Competition Bureau recently speak on issues related to COVID-19, and we would echo concerns raised by the Bureau that when you look at advertising through the lens of the consumer and what that consumer sees, there's always special attention given by, by regulators and by Ad Standards as well to the more vulnerable consumer. And right now, in some ways, we are all vulnerable consumers, meaning that we are looking for the ray of light. We're looking for that glimmer of hope and afraid, concerned. So being in that more sensitive environment, want to be very careful to absolutely claim what you're entitled to claim, but be careful not to cross a bar. Always, this applies for submissions to Health Canada, applies for any ad that would be adjudicated by Ad Standards. The onus will always be on the advertiser to have competent and reliable evidence to substantiate its claims. So if we receive a consumer complaint, we may ask for that substantiation for the claim. And that evidence needs to be available on file with the advertiser before the claim is made. So I want to pause the slides here for just a moment to talk a little bit about our process. As I've mentioned a couple of times when we review and how we review. So we have the pre-clearance regime, which you can submit for pre-clearance. Our code, Canadian complaints under the code are entirely complaints driven. Enforcement of the code is complaints driven, which means that we receive a consumer complaint and we review it at the staff level. So that's when we're assessing, in the case of these 30 complaints, we took the 21 complaints and looked and said, okay, do these raise an issue under the clauses of the Canadian Code of Advertising Standards? In the case of 11 complaints that we received, about 9 different ads, we assessed that there was no issue under the code as it's currently applied and interpreted. The other complaints where we see that there is a potential issue raised under the code, we first reach out to the advertiser, and the advertiser has a chance to respond. If it's a complaint about Clause 1, then we move forward from there. If it's a complaint under Clause 10 or 14, that's the safety and acceptable depictions and portrayals, the advertiser's response goes back to the consumer to determine whether or not they're satisfied with the complaint. When we talk about that, so those are the various stages where complaints related to COVID-19 are right now. When a matter goes forward for determination, it's determined by a council, which is a 7-person panel, independent from Ad Standards staff, made up of members of the industry as well as the general public, with a view to assessing the ads under the code to determine whether or not the complaint is upheld or whether the advertising complies. So when we talk about the complaints moving through that process and their ultimate adjudication, that's where things net out. So moving on to the next slide. Wanted to take a few minutes just to bring a global perspective and kind of put Canada in the broader framework of where we stand. As I mentioned, we've received 30 consumer complaints that are COVID-19 up to date. We are, Ad Standards is a member of a larger organization of other similar advertising self-regulatory bodies around the world. We're not the only ones. And we, as well as many others, as well as ICAS, which is this body of self-regulators, have put out advisories and notices related to COVID-19. We'll go on to the next slide and talk a little bit about the numbers specific that we've seen. These relate to ICAS's, so the other organizations in our in this international group, and what they've seen so far, which largely mirrors what we are seeing. Now, these stats are a little old and don't include the European markets. So this is the US, Canada, Brazil, Colombia, India, Australia, New Zealand, the UAE, and South Africa. When you add in the European nations, globally, self-regulatory organizations, or SROs, have dealt with more than 1,600 COVID-related advertising complaints thus far. And there have also been independent investigations, 403 independent organizations as of a week or so ago, related to COVID-19. So obviously, global pandemic, global concerns, and the questions that are coming up for advertising in Canada are reflected more broadly. Not surprisingly, we're seeing many of the same complaints coming up in these other jurisdictions as well. Misleading health claims leading the way in terms of concerns. What's listed here is offensive advertising and fear-mongering, promotion of unsafe behavior. So those align with our clauses related to acceptable depictions and portrayals, which could be that encouraging of unsafe or dangerous behavior. Fear-mongering, we have the superstitions and playing upon fears in our code as well, and promotion of unsafe behavior. So is it actually promoting something illegal, or is it promoting something unsafe? Again, a cross range of different organizations about which complaints have been received. Again, health and cleaning products, not surprisingly, the OTCs, supplements. Interestingly, alcohol, we would think of that as alcoholic beverages. In other jurisdictions, that perhaps is relating to the disinfecting claims. But we're also seeing food and beverages and financial services. So anyone advertising anything could get caught up in this broader COVID concerns, whether it's related specifically to health products, as one might think, but also in terms of general depictions and portrayals, how consumers, individuals in the ads are being shown, and what sensitivities is that triggering for the consumers who are engaging with the advertising content. Many SROs, self-regulatory organizations, have a fast-track procedure for COVID-19 complaints, and we also prioritize the COVID-19 complaints when they come in. So we're checking daily and to triage and pull COVID-related complaints so that they can be sent either immediately to Health Canada or put immediately into our queue for review and response. So with that, I know there are a lot of questions coming in, so why don't we move on forward to addressing the questions.
Sounds great, and thank you, Catherine. So moving right into the Q&A right now. So just seeing the first question here from Sherry. Are there any legal supers that need to be added with regards to approved by Health Canada? So in respect of advertising claims, and talking now about those regulated products, so hand sanitizers and hard surface disinfectants and medical devices, you're not allowed to say that it has been approved or indicate in any way that it might be endorsed by Health Canada. The closest that you can really get is a claim that the product has been authorized for sale by Health Canada, and that refers to advertising. Now, in respect to your labeling, there are some very prescriptive labeling disclosures that need to be included, and most importantly, for hand sanitizers and hard surface disinfectants, you have to include the natural health product number or the drug identification number. and alluding back to what I discussed earlier in terms of the uptick in enforcement we're seeing, Health Canada has asked members of the public to report any products that they see for sale that do not include those licensing numbers, because they really are now trying to crack down on some of those non-compliant products that have made their way into the market. Okay, so now moving down into the list. Okay. Are there any other countries that might be favored for the importation of hand sanitizers other than the U.S.? I'll ask Louis if he has a point of view on that.
Yeah. So well, actually, first of all, let me just mention that there are way more questions asked than we could possibly answer within this time frame. So you're always free to reach out to us, say, following the webinar. But one of the questions are there any other countries that might be favored for the importation of hand sanitizers other than the U.S.? I just want to be clear that Health Canada is not, overtly saying that they're somehow favoring the U.S. over other countries. They're using kind of a similar country concept to their approach. So I would suggest that other countries that might be favored would be the European Union, or sorry, let me rephrase, countries within the European Union, as well as the UK and Australia, as well as a number of other countries. But to say that there's any specific country that's not favored, we haven't really gone that far with Health Canada. I mean, they look at each notification or submission as on a case-by-case basis, and it's only through application that we're going to really learn that. And in our experience, frankly, the vast majority of products that have worked through the system have been the United States, from the United States, because they're our closest neighbor. So it's just natural that it would be from the United States. The next question I see is, if you apply for an NPN under the expedited approach, do you still have to send a specification for your product? So if you're applying for an NPN under the expedited approach, typically this would be what we call a compendial application, which is a class 1 natural health product application, as there's a monograph for hand sanitizers. And the reality is you actually wouldn't submit a specification sheet for any class 1 application, so it would not form part of the application process. In terms of questions, sorry, here's one for you, Renee. Does a hand sanitizer advertiser have to state either in a video or audio the percentage of alcohol contained in their product? Or Catherine, one of you.
I'll jump in and no, they don't in the advertising. I mean, again, that will come down to a labeling issue. So really, in terms of advertising, it really limited to the approved uses and indications for the product, but not required to specifically call out that percentage of alcohol. And I'm just going to hand it over to Catherine now to answer 2 questions that fall within her preview.
Sure. And I'll say it's the question you just answered, that was just asked and answered. Yeah, there's no legal requirement if we're doing a pre-approval for the percentage of alcohol. But of course, if there is a hand sanitizer that's implying that it could effectively kill COVID-19 or kill viruses and had a low percentage alcohol, that may be material information. It may be something that while not technically required, perhaps should be disclosed, just because of depending on the general impression created by the ad. I could see consumers being upset that they could self a sanitizer but may not have the percentage of alcohol relative to current environment that we're in right now. A couple of questions have come up, both about monitoring of advertising, as well as what happens when someone does not comply with an orders of ad standards. And so I thought it helpful to kind of deal with both the pre and post complaint areas. So there are bodies that are looking out for deceptive advertising. At Ad Standards, we're not staffed to go out and search for cases. So we rely on the complaints from consumers coming in, and then we address and carry those forward. But the Competition Bureau Health Canada, and as well as certain provincial consumer protection offices have declared mandates to go out and look for potentially misleading advertising, as well as triaging complaints themselves. So while we're complaints driven, there are other bodies that are looking proactively, and certainly if you're aware as a consumer of an issue, that's something that can be brought to our attention. If you're aware as a competitor, we also have an advertiser dispute process that allows for disputes between advertisers. So a couple of different avenues that we offer. What happens if we come up, we had ad standards and our standards council arrives at a decision that an ad is non-compliant and the advertiser does not comply with that decision? First, I'll say we're very grateful that we have support of the industry. So I would say 98, maybe 99% of the time, the advertiser wants to do the right thing. And so if they receive a decision that the ad is found to be misleading by the Standards Council with a chance for appeal, then the ad will be amended or withdrawn. In the rare instance where it's not, we first reach out to media, and we have great support from whether it be from the broadcasters, from print host media, various media providers in terms of assisting in enforcement when that arises. If it is something like the advertiser's own website where there isn't further recourse, we have the ability to forward those cases to the Competition Bureau. So in those very rare instances where an advertiser does not wish to comply with the decision of the Standards Council or a dispute panel in the case of an advertising dispute, those matters are referred to the Competition Bureau, who has the greater enforcement teeth in terms of injunctions, in terms of monetary penalties and whatnot.
Thank you, Catherine. So I'm going to answer the next question, and the question is: do you have a sense of the size of the non-COVID regulatory backlog and how we can help Health Canada address it? So this is actually a phenomenally good question, and it's a struggle we're dealing with on a day-to-day basis, and it's a very timely question. So Health Canada, on the oncoming of COVID-19, has basically said, we're going to help you industry with all these urgent products, and we're going to turn over backwards to get things done in a day. But they've effectively turned their back on everything else. And so the problem is it's becoming increasingly difficult for our clients and members of the industry to stay in business in their day-to-day business and challenge with the economic situation. This is a really important issue. So, some examples would be Health Canada takes the position that because of COVID-19, it's so important to focus on things like hand sanitizers, which it is. When a company goes in and says, I have 3 products that I want to launch, and normally it would take 60 or 90 days to get them approved, it's now sometimes, well, we're just not looking at it. Or we're going to look at it when we get to, and it could, for all we know, this could take a year now to catch up on backlog. So companies are being hindered from doing their day-to-day business, and this could effectively compound the economic impact of the overall situation. We're actually dealing with an issue right now where we have a client who applied for a license. Health Canada made an error on its issuance of a license, and they're just not looking at they're not dealing with the correction of the error. So effectively, our client has an inapplicable license, and who knows when it's going to be corrected. So these are some very, very challenging times on the non-COVID related side of the business. It's too early to tell where it's going to go. Health Canada has not proposed a plan. And frankly, Health Canada, hasn't even acknowledged the issue as of yet. And I think they will, but they're not there yet. Their head's still on COVID, and their head really isn't in the other parts of the day-to-day business that companies need to address to be in business.
Okay, so thank you very much, Louis. And just looking at the time, it looks like we've reached the end of the webinar, and wanted again to thank everyone for joining us today. And as I noted earlier, I know there's a lot of great questions there, so if you want to reach out to us and ask those to us, please do. A big thank you again to Catherine and End Standards for co-hosting this with us. It was a pleasure. And to everyone for joining, thank you. Be safe out there. And yeah, we're all in this together. So happy to share this time with you.